Real people, real opinions.
Real Talk Radio. The multi-award winning Niall Boylan Show.
Ireland's classic hits.
The Supreme Court yesterday ruled that a section of law related to the Sexual Offences Act is unconstitutional. As it stands, Section 3.5 of the Criminal Law Sexual Offences Act provides a defence for the accused charged with defilement of a child under the age of 17 to demonstrate they reasonably believed the complainant was aged over 17. Now, it requires that a person using the defence must prove it on the balance of probability. Now, I don't really understand it too well, but I kind of get the gist of it. But to give us more information, to make a little bit of sense of all this, I'm going to talk to Solicitor Daniel Kreith, and Daniel has an array of experience in many areas, including criminal law, sexual offences and defamation as well. Good afternoon, good evening to you, Daniel. How are you?
Good evening, Niall. I'm good, thanks.
Daniel, this seems quite complicated, but it probably isn't. I'm assuming it's just if somebody doesn't mention their age and you make a reasonable assumption that it gives you some protection in law. Was that essentially what this section was about?
I guess, unfortunately, it would be more complicated than that. I guess if I was to maybe deal with the ruling that came out today and to maybe explain its significance, I guess before I get into that, perhaps it might be an easier for listeners if I explained what the prosecution would need to prove for an accused person to be convicted of a sexual assault generally, and then that will sort of explain then how it will affect this ruling, how it affects certain precedents.
Before you do that, by the way, can you explain to me, because I'm always confused by the word defilement, because it's not a word that's used regularly when we talk about sexual assault. Is there a difference when we talk about sexual assault versus rape versus defilement?
I guess to explain, like the offence of rape is different to a sexual assault. So, for the charge of rape to be put proper to someone, there has to be either penetration of the vagina with the penis. That would be rape under Section 2 of the Criminal Law Rape Amendment Act. There is also other forms of rape under Section 4 of the 1990 Act, where that would relate to digital penetration of the vagina, i.e. the fingers, penetration by the object, or penetration of the anus by the penis. So that there the charges of rape. Sexual assault can be very minor in nature. For instance, if someone rubs another person's breast or even another person's genital area on the outside of clothing, it could be as minor as that to more serious sexual assaults where there could be digital penetration of the anus. So rape is a narrower charge compared to sexual assault. Sexual assault deals with a wide range of sexual acts.
Okay, and the word defilement, by the way, where does that come into it? Why do they? Because you don't hear that word used too often, but you do hear it now and again. So what is the word defilement, or where does that come into it? Defilement,
well, in relation to even how we would in the legal how we would we would refer to sexual assault,
right,
more so than defilement. It is referred to in the legislation, but again, legislation has been predated, many years. So it was more of an archaic term, but really,
right. Okay.
It would be sexual assault would be the phrase.
Okay, so to get around to this Section 3.5 of the Criminal Law Sexual Offences Act that provides a defence for accused the charge of defilement for a reasonable, what they call a reasonable balance of probabilities, defence that they assumed the person was over the age of 17. So you wanted to give us an example of how that was used yesterday in the Supreme Court case. So where did this all come from, or where did it start?
I guess, would you like me to give your listeners like a practical example of where
absolutely.
An accused person could end up? I guess the first example that would come to mind for me where this could become an issue is if a person is on a night out and they frequent a nightclub which is over 18s only, and there is security personnel on the door of the nightclub checking for IDs. You go into the nightclub, you meet a person in that nightclub, you go home with them, and then you engage in sexual acts. And then it transpires that that person was actually under the age of 17, and as such, under the law, is not capable of giving consent to any act of a sexual nature. That essentially, so to explain the sexual assault, so that is the nature of. To prove a sexual assault, there has to be physical contact of a sexual nature, and that contact must be made without the consent of the other party. However, the issue is a young person under the age of 17 cannot give consent in Irish law. And so I guess my example with the person in a nightclub, that's where this would have posed difficulties. Someone on a night out in a nightclub meeting a person in a nightclub, that's a practical example of where you would have...
Yeah, so a 21-year-old lad is out and he meets a girl who he assumes is over 18 because she's in the nightclub in the first place, but turns out she's 16 years of age, and her parents would take a case with her to court of statutory rape, I imagine. That's the charge that would be. Yes,
that's essentially, yes, or even quite simply, like if there was no sexual intercourse as such, just even a charge of sexual assault or defilement, it would come on.
So as it stood the day before yesterday, did that person have a reasonable expectation to have a defence to say, well, I thought she was 18 and I assumed she was 18 because she told me she was and she was in a nightclub? Would that person have a reasonable defence?
I guess just the age of consent is 17. So, but yes, in practical terms, if you were in the nightclub example, you would assume someone is 18. But your question being that did someone have a defence before yesterday? The answer is they did. However, to rely upon, for an accused person to rely upon that defence, the jury had to be convinced on the balance of probabilities that that defence was reasonable. And where this became an issue is under Article 38(1) of the Constitution, an accused person has a right to trial by due course of law. And fundamentally, in criminal trials, it is the job of the prosecution to prove their case beyond a reasonable doubt. So if they bring charges against any person, it's their duty to prove each necessary proof for the charge beyond a reasonable doubt. If the jury have a reasonable doubt in relation to the guilt or the innocence of the accused, they should acquit. They should acquit them. But the issue here was that the accused person who was trying to put forward this defence of mistaken belief as to the age of the other party, the jury had to be convinced on the balance of probabilities, i.e. they had to be 51% convinced that the defence, that the accused had established a defence, rather than them being under a reasonable doubt that defence was there.
Okay.
So the accused basically had to meet a higher evidential or it was a legal threshold of proof than they ordinarily would have in any other criminal trial, and that's where it became
unconstitutional.
An issue with the constitutional, and that's why in the High Court, Ms. Justice Stack made the ruling she did, and that's why it was the appeal that was brought by the state was unanimously dismissed by all 7 judges of the Supreme Court yesterday, because it was set that there was this higher standard of proof, and it would be potentially prejudicial to an accused person. There would be a higher chance of
because
conviction.
you obviously have an assumption of innocence before guilt. So so in other words, you were trying to prove you were innocent rather than prove you were guilty.
Yes, that's also the case as well. Yes, there is presumption, and there was issues with that as well.
Mm-hmm. So where does that leave us then going forward? Does that then is that problematic then, I suppose? Now, let's be clear, these cases would be unusual. When I say unusual, less likely than, your everyday rape case or sexual assault case where somebody has a reasonable defence of age. So they would be less likely to appear in court, these cases, would they? Is that my
Absolutely, I'd agree. It would be very much these would be very much set in a narrow set of facts. Mm-hmm. The nightclub example being one. The person would, I guess, in theory, would have to be a stranger to the accused.
Yes,
because if you knew the person, to assert that defence would be extremely difficult, even more.
Of course,
so they would be in. Will it change? I think it will make the jury's job a bit easier. So now, at the start of any trial, the jury or the prosecution explains to the jury that it's their job to prove their case beyond a reasonable doubt.
Yeah, in other words, if you have any doubt whatsoever that the accused didn't know that she was under the age of 17, well, then you must acquit them. So that's essentially what they're saying.
Well, yes, and then the whole way through the trial, then they can that's the threshold they know they have to be thinking about. Where before they have to be thinking about, this specific aspect of the trial had to be proved on the balance of probabilities, but the rest was beyond a reasonable doubt. I would say it would be quite confusing for 12 members of the public to have to basically balance two separate tests in one case. So things have been made easier that way. Like the court did say that there is still an evidential burden on any accused person relying on this defence. So, i.e., it is up to the accused person to put forward the defence of mistaken belief as to age. They will have to put that forward. So I guess that might then have, because the next question your ministers might have is, will there be a lot of appeals going in?
I was going to say that. Does that have any effect on current cases or people who are currently behind bars? I mean, will it have any effect on those?
I guess we wouldn't be able to talk about any individual cases.
No, of course not.
Just speaking generally, there will be a certain number of convicted persons who will be able to lodge an appeal relying on this point of law. However, I guess in terms of an appeal, the defence would have to have been put forward at trial for it to be relied upon as a ground of appeal for any convicted person. So I think that would narrow the scope of.
Yeah, there's not going to be a flood of appeals on this particular issue.
No, it won't be. No, it won't be a flood of appeals. No. But there will be a number, but it would be a small number.
And just from your own personal view, Daniel, do you, because you've studied law and know a lot more about it than I do you think this is a good thing or is this a bad thing? I mean, does this then reduce the chances of conviction by somebody, because we're always talking about the fact that we have low conviction rates when it comes to rape and sexual assault, because they are difficult cases to prove, because you're generally relying on the testimony of two people and who is it you believe, because there's rarely witnesses. So is this a bad thing for convictions when it comes to rape cases?
Well, it wouldn't be. I guess I wouldn't be for me to give an opinion on that. I think it makes the jury's job easier in having to decide guilt or innocence in cases of this type.
Okay.
So I think it is beneficial from that point of view. I guess just as well to process this as well, that this will really essentially only relate to complainants who are 15 and 16. There is a separate section within the legislation dealing with children under the age of 15, and that's unaffected. So it is a very narrow cohort of people that it would affect. I like it. As I say, it would make the jury's job easier.
Absolutely.
A jury it's very difficult for 12 members of the public dealing with any criminal trial, and to make their job a bit easier is always more beneficial.
In Ireland,
it would.
Yes. Well, seems we're talking about it because we were talking about cases there going back about 3 weeks ago, I think it was, in relation to rape cases here in Ireland and the age of consent, etc., etc. And we were talking about the fact that I suppose, the majority of the population probably lost their virginity at the age of 16. And there would be nothing unusual about that. People tend to lose their virginity. I think that's the average age for losing your virginity in Ireland, to 16 years of age. But where does the law stand? And I remember there was a case going back about 7-8 years ago, we discussed it on the air, of a 16-year-old, or was it a 17-year-old, with a 16-year-old in a nightclub in Dublin who had sex in the toilets. And in that particular case, the judge dismissed the case But I have heard of other cases similar to that where the 17-year-old boy or man would have been given a suspended sentence or indeed incarcerated. So where does the law stand on people who are under the age of 17, where both parties are under the age of 17? You know, and both close to 17, I suppose. Where does the law stand in Ireland on that? Is there an exception, or is that up to the judge's discretion?
There is that is completely separate to
of
what
course
the ruling today.
Yeah.
But in those circumstances, the accused person would be relying on the Romeo and Juliet defence that yes, but both parties were between the ages of 15 and 17, but there was either the accused person, i.e. the boy in all these situations, was either younger or within 2 years of the complainant. And now it doesn't stop there, because consent is off the table in these cases,
because neither can consent.
Can't give consent. It has to as well to be. There has to be that. It's voluntary. It's a joint. It's something both parties want to do. That there can't be any pressure or coercion. It's akin to consent, but it's not consent in the legal terms. So that is the defence in those particular scenarios. That is the defence and accused would rely upon is the Romeo and Juliet defence, is what it's called more colloquially.
There has also been the argument for many, many years that Ireland should follow most countries in Europe and reduce the age of consent to 16 years of age. In the UK, it's 16 years of age. In many other countries, it's even lower. It's 15, I think, in Germany. But do you believe that, I mean, we've gone from 21 down to 18. At one stage, the age of consent was different for people who were homosexual and people there who were heterosexual, but that's changed now and they're both the same. But do you think we'll see a day where there has been suggestions in the past that the Irish age of consent should be reduced to 16? Do you see that happening in the future?
I think there's every possibility. As you rightly point out, the age of consent in the UK is 16. And I guess the SSA even younger in different parts of Europe,
which is quite concerning, to be honest with you, when you think about 15.
I think there would have to be a certain there would be a line on. I would think, but yeah, look, as societies evolve, I think societies generally are becoming more liberal in relation to various matters. I mean, we had a referendum on gay marriage that was passed. We've had a referendum on abortion. I guess society takes steps, step by step. Societies are becoming more liberalised. So, I would not be surprised if the age of consent is lowered to 16.
Yeah. I mean, well, I suppose it just brings us into line with the rest of Europe, then, doesn't it? Really.
Well, it does. Well, I guess, yeah, as I say, some countries are lower within Europe, and we'd be in line with the UK as such.
Mm-hmm. Okay, well, look, it's very interesting, and I know law is a very complicated thing, and fair play to you, Daniel, because I don't think I could retain that much information in my head in relation to every piece of legislation and every section of every piece of legislation as well. As you say, it probably won't have too much effect on the law going forward, because it's a very narrow scope of cases that would come under this type of remit, where somebody would have a reasonable assumption that a person was under the age, as you said, the balance of probabilities, which would probably only be in a stranger situation, as you said, in a nightclub or a bar where they didn't know the person, and also maybe the person lied about their age when they asked them, if they did indeed ask. So listen, thank you very much indeed for explaining it, Daniel, and I appreciate you coming on the air. Daniel Kreith, thank you very much indeed.
Thanks, Niall. Thank you.
Real people, real opinions.
Real Talk Radio, the multi-award winning Niall Boylan Show.